Matt Day here with Parsons, Graham and Day, and we've had some adoption cases with some issues that have raised some questions about what can be done after an adoption has gone through. Generally speaking, if it's a consent adoption, so let's just use mother as an example. The mother consents to the adoption and then the decree of adoption is put in place. Generally speaking, that is final. It is done. Okay. The consent would contain, most likely, or should contain, that mother understands that she's giving up and terminating her parental rights, that she doesn't have to do that, that she could maybe have a hearing on best interest, depending on what type of adoption it is, but essentially she has some due process rights that she could enforce rather than consent to the adoption. All right. Once that final decree goes in to effect, she's probably out of luck. Now, if you find yourself in that situation, don't just watch a YouTube video and say, well, gosh, I guess I can't do anything. Contact an attorney, run through the facts with them, make sure that an attorney analyzes your case for all of these situations, right? But there's another situation in which the adoption occurs essentially by default. Let's use father this time. Father does not show up and his rights are terminated, and he doesn't show up and a decree of adoption is put in place. There may be some legitimate questions as to his ability to show up and the amount of notice that he received. What type of notice did he receive as to the ongoing adoption case? The adoption statutes specify what needs to be in your notice to a parent, especially when you're doing something like an adoption without consent. You may hear it referred to as an AWOC, adoption without consent. The parent has to have proper notice under the statutes. And if it's an Indian child, the notice requirements are even more because there are greater protections under the Oklahoma Indian Child Welfare Act and the Federal Indian Child Welfare Act. So there may be notice issues that would allow a decree to be vacated and set aside so that that parent or parents can come back in and essentially ask that adoption not go through. All right. So you find yourself in a situation in which a child has been adopted or is about to be adopted, or they have just filed the petition to get the case started. You need to speak to an attorney so that you can know exactly what your rights are in any given situation. Don't go into the courtroom without representation. If you find yourself in the courtroom without representation and you can't afford representation, you need to make sure and ask for representation. But don't try and handle an adoption by yourself. Don't try and handle really any legal matter by yourself. But make sure you get the advice and counsel of an attorney who practices in that area and who can walk you through what the rights are. Because even after a decree of adoption is in, there may be fundamental flaws in the process that allow that decree to be vacated or reopened so that that case can essentially be delved back into. All right? For more information, visit our website, www.pdtulsalaw.com.
The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons, Graham and Day and anyone watching this video.